Hi, my name is Robert Shelley with Shelley Law, and my law firm assists chiropractic clinics with drafting, Chiropractic Associate, employment agreements, and independent contractor agreements. So today I'm going to go over 5 key things that make a successful chiropractic associate contract. So first, how are you going to classify this person? So, are you going to make them an employee or an independent contractor? The IRS has a 20-factor test that kind of helps to determine whether somebody is an employee or an independent contractor. I find, especially in the chiropractic industry, many of the clinics want to designate any associate as an independent contractor. May not be that way. So you need to look and determine what type of relationship you have with this person. Now, obviously, there are many times where classifying the chiropractic associate as an independent contractor makes a lot of sense. Maybe they're only working a couple days a week, a couple days a month, part-time basis, schedules up to them, that type of thing. That would make sense. But if someone's working 9 to 5, you're telling them what their schedule is, who they see, they're most likely an employee. So anyway, how you determine or which designation you determine for them will then kind of inform the next point, which is how you're going to pay them. So the compensation structure. So for the most part, it's either a guaranteed base salary, some kind of net collections agreement where the chiropractic associate will get a percentage of any of the collections received by the practice based upon the personally performed services of the chiropractor, or a combination of both. I find a hybrid's probably the best way to go, where they get a minimum guarantee, but then a large portion of their compensation is tied to their productivity. You don't want to have somebody brought in on a guaranteed base salary and then them not be very productive. That's not good for anybody. So having some kind of productivity put into the compensation structure, pushes them to work a little bit harder. Plus, they'll make more money if they do. Next is restrictive covenants, non-compete, non-solicit. There are a handful of states where the non-competes are unenforceable, but for the most part, they're enforceable in the vast majority of states in the country. So how long do you want the non-compete to be? What's the geographic restriction of it? And then the non-solicit, once again, how long do you want it to be? And then you don't want them to be able to actively solicit patients or key members of your staff. I mean, the nightmare scenario for any practice owner is that you bring in a chiropractic associate, they leave, snag a bunch of patients, take a bunch of key employees, set up shop nearby. Having a strong non-compete, non-solicit can stop them from doing that. Next would be malpractice insurance. Not a huge problem in the chiropractic industry, not overly expensive, but it's still important. So you need to figure out what type of policy you're going to pay for, either a claims-made or occurrence-based policy. If it's a claims-made policy, someone's going to have to purchase tail insurance. Normally, most private practices will have a claims-made policy, and then they'll shift the burden on paying for tail insurance to the employee. Or I guess if they're an independent contractor, that as well. And then finally, notice. So how much notice does the chiropractic associate have to provide before they leave? So that's called without cause termination, which simply means either party can terminate the agreement at any time for any reason with a certain amount of notice to the other. 60 or 90 is kind of the industry standard. Obviously, if you're a practice, you want it to be a longer notice period so you have more time to replace them. Whereas if you're the provider, shorter the better, because it gives you a little more flexibility and movement. So I think a balance of protecting the employer's interests with being fair to the chiropractic associate is the best way of going. When I have an owner who wants me just to kind of put the screws to the employee at every possible point in the contract, usually those positions have high turnover. It doesn't really, kind of contribute to a collegial work environment. So I think a good balance is better in the long term financially for the owner, because there's not so much turnover, and having to recruit and train constantly is just a terrible burden on an owner. I know this from experience. All right, if you want a chiropractic associate employment contract or independent contractor agreement drafted, you can contact my law firm at the contact info listed below in the description. If you have any questions, please leave them in the comments. I'll answer all of them. And I appreciate you watching the video. Thank you. Bye.